Welcome everyone to our evening session. My name is Justin Krieger. I'm one of the partners at Client First. I head up the financial planning team, so welcome. See a couple of green shirts in here. I do have to admit the noon session was much more festive with St. Patty's Day. There was probably 15 people in green. So before I introduce our speaker for tonight, we always like to do trivia, so I'm doing St. Patty's trivia. So it's not going to be on leprechauns or beer or Lucky Charms or four-leaf clovers. First, a little history. Went back. Pretty interesting that, I don't know if any of you know this, St. Patrick was not Irish, allegedly. The story goes he was actually a rich British kid who got kidnapped and was put into Irish jail or prison. And the story goes that his faith and Christianity grew when he was imprisoned. So then now he's the kind of the patron saint of Ireland and the celebration of Christianity coming to Ireland. So pretty cool history there. But on to the trivia. It's hard to look up St. Patrick's Day trivia because there's so many stories. So trivia for tonight is, what year did St. Patrick's Day become an official national holiday in Ireland? You can shout your guess out loud now. 1436.
1946.
1946. 1864. Nope. 1903.
That's what I was going to say.
I was surprised. I thought it would have been much sooner than that, but 1903. All right. Tonight's speaker, Rob Melick. We love Rob. He does estate planning for most of our clients. We love him because he doesn't act like a lawyer. He's not one of these stuffy attorneys that just wears suits every day, and he loves helping people every day, and that's what Client First is about. So I'll turn it over to Rob.
All right, so thank you again to Client First for the opportunity to speak here today. I know there's some familiar faces in the audience, people I've met with before, clients of mine. So what I'm going to do for this presentation, it's going to be slightly different than the types of things I typically talk about. I'm really going to divide it into two parts. The first half is going to be a lot of repetition. The first half is going to be some basics of estate planning. What we want to look for in estate plan, some of the misconceptions of estate planning, because I can tell you, one of the main things I've seen in my practice is that there's a lot of misconceptions about what an estate plan should have, what the consequences are of having various types of estate plans in place. So I want to give some of the basics and dispel some of the myths there. So that's the part that should be kind of similar to what you've expected from me before if you either attended a seminar of mine, heard me on the radio, attended a class that I teach at Moraine Park, or if you're a client of mine, you heard me mention it to you directly. The second part is kind of a little bit of a deviation. I want to talk about some of the components of planning that aren't necessarily related to estate plan, but are nevertheless a very important part of approaching retirement or approaching end of life estate planning. The title of my presentation, Friends in High Places. Again, for those of you who don't know me, I'm a huge country music fan. That's an homage to Friends in Low Places, the Garth Brooks song, which is my sole karaoke song. It's probably the only song I've ever karaoke to in my life. Not that I'm a big karaoke guy, but I can hit some of those notes decently well. So that is the title of this presentation. So any presentation that I've given, I always start with this slide. Now, I modified the third line of this slide to comport with the theme of this presentation. But let's start with that initial fact there. 90% of American adults do not have an estate plan. So if there are people in the audience, I'm not going to ask for a show of hands, but if there's people in the audience that don't have an estate plan, you're in good company. 90% of American adults do not have an estate plan in place. Now, I always feel it's necessary to defend this statement a little bit and explain exactly what this means. Adults includes anybody over the age of 18. Now, to someone who may not be as familiar with estate plan, you may think, well, why in the world would an 18-year-old need an estate plan? I'm going to say this here, and I'm going to defend this statement as I go forward tonight. Every single person over the age of 18 should have an estate plan. Every single one. Now, please don't misunderstand me. I'm not suggesting that an 18-year-old needs the exact same type of plan as a couple who's approaching retirement, but they nevertheless need some form of estate planning. We'll talk about more of the specifics of that as we go forward here tonight. One of the main reasons I found in my experience, regardless of age, as to why people do not create estate plans is because of the perceived costs of those estate plans. And attorney costs very dramatically when it comes to estate plan, but I can tell you unequivocally is this, that second bullet point. Passing away without an estate plan always costs significantly more than creating one. Why do I say that? Because under Wisconsin law, if we pass away without an estate plan, the state of Wisconsin creates one for us. And it may or may not necessarily be the type of plan we want. And it's going to very often require court intervention and governmental interference to get through. This third point is the point that I change up in this slide. There are many important legal components of a profit plan, and that's what we're going to focus on for the first half of the presentation tonight. The second half of the presentation is to focus on the non-legal aspects. And just to be abundantly clear, non-legal is not the same as illegal, okay? I'm not advocating we do anything illegal, okay? Non-legal means these are services that are not completed by a lawyer, services that other professionals, such as the folks at Client First, can offer you. So that's what I'm going to be referring to in the second half of the presentation tonight. So the next slide, I want to focus on what I call the foundation of any well-drafted estate plan, and those are the powers of attorney. So again, with powers of attorney, broadly speaking, there are two types of powers of attorney. There's a financial power of attorney and a healthcare power of attorney. And what I've found is that the healthcare power of attorney is the one that's a little more intuitive to my seminar attendees. So I'm going to explain what that one is first. Healthcare power of attorney allows you to nominate people who can make medical decisions for you if you're alive, but if you're incapacitated. And we go back to the topic of misconceptions. There are two very important misconceptions when it comes to healthcare powers of attorney. The first of those misconceptions is that spouses automatically have those rights. They don't. So I'm going to walk you through a hypothetical to kind of accentuate that point a little bit. I turned 40 years old in July. I'll be 41 this upcoming July. Statistically speaking, most 40-year-olds do not have estate planning documents in place. For purposes of this hypothetical, let's assume I did anything else for a living other than what I do. I'm a first-generation lawyer, so let's assume I did not do what I did for a living. There would probably be a very good chance I do not have the proper estate planning documents in place if I didn't do what I did for a living. So I'm presenting at any other seminar you can imagine. I'm driving home from this appointment. I'm going on Highway 33 to get back home. Someone crosses the yellow line, gets me head on. I'm taken to the hospital. I'm in a coma. I'm completely unresponsive. Can my wife make medical decisions for me while I'm incapacitated? The answer is no. She cannot. It gets worse. She can't even receive medical information about me because sharing that information would violate my HIPAA rights. That health information can only be shared with my consent. If I'm in a coma, I, of course, cannot give that consent. So that's why married couples need to have these healthcare powers of attorney. A lot of times people think, well, I'm married, I can make those decisions. No, you can't. Not without a medical power of attorney. The second common misconception comes into play with parents who have children who have just reached the age of 18. People think that if their child is a senior in high school, 18, living at home, something happens to them, they can make medical decisions. No, they can't. The moment that child reaches the age of 18, we as parents lose the ability to make those decisions. So some people in the audience have children who are slightly over or around the age of 18. This is something we need to think about. There are people in the audience who have grandchildren who are at or around the age of 18. This is something that they ought to inform their children about to make sure that we have these documents in place. Because again, once that child reaches the age of 18, we as parents lose the ability to make medical decisions and the ability to receive information about that person's care. The next type of power of attorney is a financial power of attorney. Okay? Financial power of attorney, as you can imagine, gives you the ability to make financial decisions on behalf of the person who's giving you that authority. Now again, I focus on the married couple. A lot of people think, well, Wisconsin's a marital property state. If one of us is incapacitated, the other one can take over. And while that certainly applies for jointly held assets, most people have assets that are not jointly held because they can't be jointly held. Examples of those assets include IRAs, 401ks, 403bs, Roth IRAs, and life insurance. So to the extent you own any of those assets, they cannot be jointly owned. They have to be individually owned. The immediate response is, well, yeah, but I have my spouse as a beneficiary. Great. The beneficiary gets the money if the holder dies. If the holder becomes incapacitated, the status as a beneficiary gives that person no ability to access those funds. So again, Once somebody turns 18, we lose that ability. So that is my defense as to why every single person over the age of 18 should have at least a basic form of an estate plan through those powers of attorney. The powers of attorney are the bedrock, the foundation of any well-drafted estate plan. Okay? One other thing that I forgot to mention at the beginning, I apologize. If there are questions along the way, just raise your hand or just shout them out. Okay? I have two boys at home who are 12 and 9. I'm used to interruptions. Feel free to just shout them out as we go here, okay? Or just shoot a hand up, whatever you feel is appropriate, okay? I'll move on to the next slide. What is a will and what does it do? By far, the most common misconception that I have with my clients is that a will is adequate. Because for most people, a will is inadequate to form an estate plan. In my experience, 80% of people who come to me thinking that their estate plans are adequate, turns out they're incorrect. They are inadequate for a variety of reasons. The will is the most common word associated with the estate plan. So I want to break it down into very simple components. What is a will and what does it do? At its core, a well-drafted will is always going to do two things. And when applicable, it's going to do a third. The first thing the well-drafted will allows you to do is determine who your beneficiaries are. Okay? Who or what, in the case of charities, are going to receive the proceeds of your estate after you pass away. It not only allows you to determine who is to receive those assets, but under what circumstances. As I mentioned before, I have two boys who are 12 and 9. We cannot turn money over to a minor, even if we wanted to. We don't. But even if we wanted to, we couldn't. We have to wait until they're at least 18. That said, I think everyone in this room has been 18 at some point in their life. Might have some younger folks in the back. Most of us are much more responsible now than we were at 18. So you can choose a higher age for them to be able to have unlimited access. The way I draft my documents, money is available for education expenses, health expenses, so on and so forth. We establish the age at which the child is deemed old enough, mature enough, responsible enough to use the money without any restrictions. So that's the first thing the well-drafted will does. The second thing the well-drafted will does is it allows you to determine who's in charge. I'm sure most of you have heard the term personal representative or executive before. By the way, they're synonymous. It's like lawyer and attorney or cop and police officer. They mean exactly the same thing. That person's job description is very easy. Doing the job is difficult, but the description is easy. Their job is to, upon death, shepherd all of the assets in the estate, pay out final expenses, and distribute the proceeds in accordance with the terms of the will. So those are the two things the well-drafted will always enables you to do. And to be honest, you probably didn't need me as an estate planning attorney to tell you that. You probably already knew that coming in. But now I'm going to explain the third one, which only applies in certain circumstances. It's something that a lot of people aren't aware of. The third thing that a well-drafted will does, again, when applicable, allows you to determine guardians for minor children. Okay? That's another huge misconception that most of my clients don't understand. They don't understand why a couple in their 20s who just had a child needs to have an estate plan. A couple that might be worth more dead than alive based upon the negative equity they have or student loans or whatever the case is. But the fact of the matter is, if that couple does not have an estate plan in place, courts are going to determine guardianship of the minor children. That's shocking. Again, based on the age demographics of most people in this room, I'd be willing to bet most of us do not have children under the age of 18. But I'd also be willing to bet many of us who don't have children under the age of 18 have grandchildren who are under the age of 18. And those people need to be made aware of this. They need to be made aware that the only way to determine guardianship of minor children is through an estate plan. Nothing else works. Notarized letters, verbal agreements, none of those work. If it's not in an estate plan, it will not be enforced. In fact, courts will make determinations regarding guardianship. Another interesting statistic as it relates to guardianship, and again, this is one of those things they don't teach in law school. You have to just learn it on your experience. Now, I'll throw it out as an interactive one, okay? Among my clients who have minor children, okay, because that's really the only relevant subgroup for this purpose, among that group, what percentage of them do you think nominate a non-family member as the guardian of their children? Any guesses? 15, I hear. 40. 10. Well, 75. Whoever said 40 has listened to my seminars before, because you're exactly right. So think about 40% in my experience. What I can tell you is this. Among that 40%, there's about a 0% chance that that non-family member would be able to go into court and successfully convince a judge to get guardianship unless it was in an estate plan. So again, This is kind of the misunderstood aspects of estate planning, okay? Making sure that people who have minor children have these types of plans in place. But here's the main thing, the bottom point here. The biggest misconception I have in my practice. Wills do not guarantee probate avoidance, okay? That is a huge point. I run into this issue, I don't want to say daily, but certainly multiple times a week. Clients of mine who are under the misconception that if they have a will, they have enough. And for most people, that simply isn't the case because wills do not guarantee that the estate avoids probate. Again, most people in this room have probably heard the term probate before, but I'm going to define it very briefly for us here. Probate is the process where a court oversees the administration of an estate. When an estate goes through probate, there's a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. As the estate planning attorney, my goal is to encourage my clients to create plans that are guaranteed to avoid probate. As we discussed before, will-based planning does not guarantee probate avoidance. So there's steps we have to take to make sure that the estate plan is set up in a way that we're guaranteed to avoid probate. Now, why do we want to avoid probate? For me, it comes down to three main reasons, okay? The first is cost. Average cost of probate in the state right now in the state of Wisconsin is between $5,000 to $10,000. That's an average. Some are more, some are less. Second is timing. Average length of probate in the state of Wisconsin is between 12 to 18 months. The third reason is publicity. Wills are public record. They have to be. Not only is the will public record, though, but the amount and the character of the assets that pass through the will are also public record. And that means any relative, any nosy neighbor, the government, the court system as a whole can know what you owned at the time of your death if you're going through probate. So I think we'd all agree on various levels that those are all three negatives. Again, cost, 5 to 10 grand, timing 12 to 18 months, and the fact that it's public record. That, of course, begs the question, how do we avoid probate? So that, of course, begs the slide of, are there ways to avoid probate? The answer is yes. So I've laid out three ways that we can do it here. Not all assets are probate assets. Many people should require the little phrases and the acronyms POD and TOD. POD means payable on death. TOD means transfer on death. Okay? Those terms are virtually synonymous. Some assets call it a POD, some assets call it a TOD. The key part is the OD, on death. It is a listing with whomever holds the asset, whether it's a bank, an insurance company, client first, whomever, that upon the death of the owner, we want the proceeds to go to the people listed. Here's the problem with that, okay? If we list human beings, as opposed to charities, not as opposed to animals, but as opposed to charities, right? Those human beings are not guaranteed to survive us. I'm a father. Many people in this room are parents. And I'll speak collectively for the parents in this room to say that we want nothing more than for our children to survive us. Unfortunately, that's not a guarantee. I can't state with any degree of certainty whether any particular human being, be it 1, 2, or even 3 generations younger than me, is going to survive me. They're likely to, but it's not guaranteed. So that's the limitation with POD and TOD assets. So again, the only guarantee I can make from an estate planning standpoint is this: the trust can't die. That's that simple. That's why I recommend trust-based planning for my clients as opposed to wills. If we want to guarantee that we're going to avoid probate, create a trust. We're going to talk more about trust because you can see that's the third option. But I want to focus on the second option for a little bit as well. If the person's net probate estate is worth less than $50,000, that's considered a small estate. And under Wisconsin law, small estates avoid probate no matter what. If we take a step back and think about it, that kind of makes sense, right? We have this process that takes 12 to 18 months, it costs $5,000 to $10,000. It stands to reason that if there are not very many assets, we have a way to avoid it. Here's the problem. Okay, and again, this is not a show of hands thing, but I'd be willing to bet that most, if not everyone in this room, has more than $50,000 worth of probate assets. The equity in one's home alone typically exceeds that $50,000 threshold. So again, for most people who are over that $50,000 threshold, will-based planning is insufficient. The only way to guarantee that we avoid probate is by creating a revocable living trust. Okay? Revocable. Now, I'm sure most people in this room know what the word revoke means, okay? But I'm going to explain what the word revoke means in an estate planning context. And there's two important things we need to know about that. One, when you create a revocable living trust, you can make whatever changes you want to it at any time. I always talk about what I call the 3 Ds and a B: death, divorce, disability, and birth. These are life events that could occur and may cause us to want to update our estate planning documents. And because the trust I recommend for 99% of my clients is revocable, you can make those changes. In fact, for a married couple, you can make those changes up until the time the second spouse passes away. Trust is fully changeable up until that time to account for those life events that may occur. The second, and arguably more important aspect of revocability is you have full control over your assets. Because the trust is revocable, you can do whatever you want with your assets. Use them in however way you want. It's maybe not the most lawyerly way to say it, but to me it gets the point across the cleanest. Your ability to do what you want with what you have is identical right now as you sit here if you don't have a trust than it would be if you walked out of my office having a completed trust. Full use, full control, full access. That's what the revocable living trust does. It is a significantly cheaper and easier alternative to going through probate. That's the third point there. The cost of a revocable living trust is significantly less than the $5,000 to $10,000 it's going to cost to go through probate. We're going to talk about this theme more as we go forward here tonight, but one of the tenets, for lack of a better word, of my practice is I want to help my clients control events that are 100% going to happen. Okay? And right now, we're going to talk about 2 events that have a 100% chance of occurring. One, we're all going to pass away at some point. I hope this is not breaking news to anybody in this room, okay? That is going to happen, okay? Until they come up with an immortality pill, we are all going to pass away at some point in time. 100% certain. The second thing that has a 100% certainty, at least under current law, is this. If we have more than $50,000 worth of probate assets, the only way to guarantee we avoid probate is to create a trust. So those 2 points, that's what I help my clients with. Of course, I can't help them with their own mortality, that I don't do. But I can enable them to create a document that guarantees that the estate will avoid probate. Because again, estate administration has a 100% chance of occurring. And the goal for most of my clients is to make that inevitable process as quick, as easy, and as inexpensive as possible. And the way to accomplish that is to create the revocable living trust. Okay? So this is kind of halftime, for lack of a better way of saying it here, because what I'm going to do is I'm going to be moving on to the friends of estate planning going forward. So I'm going to open it up to questions here if there are any. Otherwise, I will move on to the second half of the presentation. Yes, ma'am. So the question was, if you have someone nominated as a power of attorney, do they have authority after death? The answer is no. Once somebody passes away, both the medical and the financial power of attorney are useless. They are done. So usually there's a congruence between who has authority during life and who has authority after death. Because here's the logic, right? The logic is, when it comes to medical decisions, we don't need to make medical decisions after somebody's deceased. I mean, that's pretty straightforward, right? But there are financial issues that obviously go beyond death. So usually we nominate the same person as the agent of the financial power of attorney as we do as the trustee of the trust. That way we have continuity in terms of who has decision-making authority. But those powers of attorney by law do cease at death. Yeah, the question is, do you have to have a will and a trust? And again, different attorneys do it in different ways. The way I do it for my clients, if I create a trust for you, I also create a will. That will basically says 2 things. The people have created a trust, and no court, no public, you're not entitled to see it. It just lets public know that there is a trust that is in place, but it keeps the terms of that trust private. So that's my recommendation, because occasionally, it doesn't happen often, but occasionally there's an asset that was not contemplated at the time of death that we need the will to be able to administer. The trust in and of itself would not be sufficient, but that happens very, very rarely. To me, out of an abundance of caution, I create a will for every single one of my clients that says, again, see the trust for distribution, and we don't need to discuss or publish the contents of that trust. Yeah, so the question is, if a spouse has a disability and we take this one spouse's name off it, the short answer is it depends. I need to see the contents of the trust to see how it was set up, because there are pros and cons to doing that, and it's all a function of the nature of the trust that was set up hypothetically. So it depends. Sometimes that is a step to take. It depends on what the nature of the trust is. So that would be a situation to discuss with your estate planning attorney to make sure that, 1, it makes sense to do, and 2, if it was already done, that it was done appropriately. Good question. The question is, are a will and a trust separate documents, or can a trust be included or created in the will? And I'm going to answer that question, but I think we're looking at it from a different perspective. The type of trust I'm referring to is a separate independent document. That is what we call an inter vivos or a living trust, okay? A separate document. There are some trusts that are created by a will, and they're called testamentary trusts, okay? A testamentary trust, if you guys have wills, if anyone in the room has a will, it should say last will and testament at the top. Testament is simply Latin for will, okay? A testamentary trust is a trust that's created by a will. Oftentimes, those are created for the benefit of minor children. Those types of trusts do not avoid probate because they are only created by the will. They have a distinct purpose to limit access or restrict access for a minor child, but they're not going to serve the purpose of what we're talking about here today in order to avoid probate. So in other words, some of you in this room may have wills that contain trust provisions, but if they were created, for lack of a better word, via the will, they're not going to avoid probate. Typically, the irrevocable trust protects assets from nursing home estate recovery. Now, there's a lot of nuances to that. The laws have changed dramatically in 2014 in terms of what we can do to protect assets. So as a general rule, and again, many nuances, I have to look at the documents and understand the totality of the circumstances, but as a general rule, people create irrevocable trusts solely for the purpose of attempting to protect assets from nursing home estate. Yeah. And we're going to talk about long-term care. Yeah, that's actually the next main topic we're talking about here. So here's what I would say, and I'm going to give a very broad answer to it, okay? Again, going back to what I discussed about legal and non-legal ways, okay? Since these law changes in 2014, the legal ways to protect assets from nursing home estate recovery have been drastically reduced. Okay? We as lawyers don't have as many tools, or the consequences of implementing the tools are significantly higher than they were before. So I'm a big proponent of long-term care insurance if you qualify for it. There are other ways that we can look into mitigating some of those expenses, and that's actually going to be a large part of what we're going to be talking about in the second half. So that's good foreshadowing there. Very good. So I'm going to talk about what I call the Friends of Estate Planning. Okay, the services that I've talked about here are services that we can mention and talk about that complement an estate plan. I'm going to talk about two of them first because I don't have specific slides on banking or Social Security optimization. So I'm going to talk about them here very briefly just because there wasn't enough to give them specific slides. When it comes to banking, it's very important that we understand how assets are at a bank. Banks are very good. I work with a lot of banks. What banks are not typically great at is making sure you have beneficiaries listed. The one takeaway, if you take away nothing else from this presentation tonight, take away this. Every asset should have a beneficiary. Now, what the nature of that beneficiary is varies based upon the asset. We're going to talk about that in much more detail. When it comes to bank assets, you have to affirmatively ask for it. Okay? Those of you who are clients at Client First does a great job of making sure that every asset has a beneficiary. Because they understand that that's the world that they're in. Bankers, not so much. So when it comes to banking, the key takeaway there is making sure that we have beneficiaries identified. And the nature of those beneficiaries depends on what type of estate plan you have. In other words, the type of estate plan drives the train in terms of beneficiaries. So it's important to work with your estate planning attorney to make sure that those assets have the proper beneficiaries. The second of these topics that does not have a specific slide is Social Security optimization. That's a service that Client First offers. They walk people through how to plan for retirement. And Social Security is a big part of retirement. There's tax favorable treatment of that money. It's an annuity. It lasts for the rest of your life. So it's very important before you retire or even during retirement to make sure that you're doing everything appropriate as it comes to when and how to take Social Security. There's different strategies with spouses. One spouse might be significantly older or younger than the other. So that's something that's very important to make sure that you're working through with Client First to make sure they're not leaving any money on the table. Or at least if you are leaving money on the table, that you're doing so consciously. Again, I go back to the example of my father, very conservative, probably the cheapest human being in the world. He said, I am taking my money at 62. I don't care. He understands he's leaving 25% on the table. That's his philosophy. Again, it's not the right strategy. Who knows? We don't know how long he's going to live. He's 66 right now. But at least he went in fully informed about the situation. So the first thing I'm going to do is I'm going to talk about life insurance. Okay? And again, life insurance is something I'm sure most people in this room have some familiarity with. Maybe many of you in this room have life insurance. Okay? I'm going to give a little bit of a primer on it, and then I'm going to talk about how it relates to estate planning in a pretty compelling way. Broadly speaking, there's two types of life insurance. There's what we call term and whole life. A term policy is for what we call a period of years. And I'll give an example here. As I mentioned earlier, I'm 40 years old. If I wanted to take out a term life insurance policy, let's say for 20 years, one of two things is going to happen. Either I'm going to be alive on my 60th birthday or I'm not. It's God's hands. I can't control that. Okay? Under a term life policy, if I'm alive on my 60th birthday, that policy just goes away. Everything I put into that policy is gone. It's insurance in case I pass away. The alternative, of course, is that I don't make it to my 60th birthday. If that's the case, assuming I pass away within the terms of the policy, terms and conditions of the policy, that policy pays out a death benefit to my beneficiary. Okay? Now, life insurance is kind of unique in that life insurance cannot be jointly owned. So when it comes to life insurance, from a beneficiary standpoint, what I recommend is having that asset go to the surviving spouse if the person is married. And then we list the trust as the contingent beneficiary. That's a little different from things like retirement accounts, which for tax reasons we purposely want to keep outside the trust. For those types of assets, we don't want the trust listed. So again, it's very important that the beneficiary designations, for lack of a better phrase, play nicely with your estate planning designation. That's why there are synergies between us and client first, making sure that that is done appropriately. Okay? Whole life insurance, on the other hand, is just what its name indicates. It pays out regardless of when you pass away. Now, as you can imagine, because it's a guaranteed payout, typically those policies are more expensive. Here's where I want to tie this in with estate planning. Again, going back to the topic of misconceptions, I hear frequently from clients this statement. Some of you in this room may even agree with this statement, so bear with me. I have a life insurance policy in place to pay for my funeral. There might be many people in this room who subscribe. Again, I'm not going to ask for a show of hands. That statement is problematic as an estate planning attorney for two reasons. Reason number one is what I call the not my kids reason, but hear me out. If you have a life insurance policy, the ultimate beneficiaries on that typically are the children. Spouse first, children second. Your children are under zero legal obligation to use that to pay for final expenses if they are listed as beneficiaries. They may have a moral obligation, but there's no legal obligation. And I have seen that in multiple circumstances in my practice where children receive life insurance proceeds and decide, Mom and Dad meant this money for me. The other kids can pay for the funeral, and they pocket the money. That, again, is the not my kids scenario, right? But the second one is one that applies regardless of the level of morality among your children, and that's nursing home issues. Okay, we've talked about nursing home quite a bit. What I want to mention here is this. If somebody has a life insurance policy, as we sit here, of course, anyone in this room, regardless of age, regardless of health, we have no idea whether any of us will ever spend a single day in a nursing home. Okay? I always go back to the, you mentioned country music fan, right? Kenny Rogers' song, The Gambler. The best that we can hope for is to die in your sleep. Thank you. I knew I'd get one Kenny Rogers fan. I'm dating myself here. I'm probably one of the youngest Kenny Rogers fans in the world, but that's exactly right. We don't know if that's going to happen, of course. So the idea with the life insurance policy, again, is if we end up in a nursing home, okay, because the whole life insurance policy has what's called a cash value, the government will require you to liquidate that before they will pay for your nursing home care. And let me explain that concept a little more broadly. When it comes to a whole life insurance policy, there's two types of things that we look at. The most common thing people think of is what's called the death benefit, right? What is this policy going to pay to our loved ones once we pass away? That's called the death benefit. And of course, that's a very important aspect of life insurance, but it's not the only one. The other one's called the cash value. If you redeem the policy, you would get a check for that number. And as you get older, and as the policy gets older, the cash value creeps very close to the death benefit, which makes sense because you're putting more money into the policy, okay? But the government says, wait a minute, you can cash that out if you want to pay for your nursing home care. So they'll require you to do that. And then that money that was supposed to be set aside no longer is. And that leaves your kids or whomever else paying the bill. Now we have remedies. We're going to talk about what those remedies are, but I just want to use life insurance as the initial primer for that to explain that life insurance is a good thing in general, but we have to make sure that we're using it appropriately. Okay. All right, so going on to banking considerations. Okay, I know I mentioned that earlier, but I do have a slide about this. I'm going to talk about it for a little bit. When it comes to banking considerations, many types of assets that are out there. Again, various interests, availability, everything we need to think about. We do absolutely need to make sure they have beneficiary designations. And I want to emphasize that point in the capital letters there. that beneficiary designations are always going to supersede will or trust beneficiary designations. And that applies whether we're talking about a bank asset or anything. This is an example I've given before. Let's say, okay, and I'm going to walk through two hypotheticals. One is a real hypothetical, one is not. I'll explain what I mean by that in a second. Okay? The first example I'm going to walk through is this. Let's say that I had set up an IRA or 401k with my employer prior to becoming self-employed, and between the time my first and my second son was born. And let's say I set that up, I have my wife as the primary beneficiary, and I have my son as the contingent beneficiary. My second son is eventually born. I dutifully create my estate plan and list everything to go 50-50 to my two kids after the two of us pass away, but I never update the beneficiary on my 401k. My wife and I pass away. My oldest son is the only beneficiary on the 401k. My will, my trust, all of it says 50-50 between the two boys. Who's the only beneficiary of the 401k going to be? That's right. That's a problem, okay? And that could easily happen. Now I'm going to change the hypothetical a little bit. Let's say, same thing I set up with. I set up the 401k. I list my wife as the primary beneficiary. I list my two sons as the contingent beneficiaries. I get divorced. I do not change my 401k designation, but I do update the trust with my second wife. I pass away. Who gets the 401k? Wife one or wife two? That's right. You can see why that could cause some problems. Okay? That's why it's very important to make sure beneficiary designations are in tune with your trust. And again, when it comes to bank assets, that's very important. As I mentioned before, with retirement assets, because of the tax consequences of that, we do not want those going to the trust. So it's important to make sure that we understand not only the beneficiary designations that are available, but what the pros and cons are of including or not including certain assets in the trust. Next slide, guardianship of minor children. I know we talked about this a little bit when I did the presentation about the will, but I feel like this is such an important topic that it merits additional consideration. Because again, this is what I call the forgotten class of estate planning candidates. Because most people that age with minor children don't think they need estate planning. They do. I'd argue that's more important. As a parent, I can live with not knowing where my money's going, that the government or that a lawyer is getting a larger portion of that money. But I had to look down and see that a court ordered guardianship to someone I didn't want to have guardianship of my kids. That's what would cause me heartache. That's what would cause me concern. So again, re-emphasizing that point. If you have minor children, you need to have an estate plan to determine guardianship. Talking long-term care, okay? Answering the question from before. Let's describe what long-term care insurance is. Long-term care insurance is again, non-legal, not illegal, way to protect assets from nursing home estate recovery. Okay? It's a form of insurance, just like any other form of insurance. It allows you to insure against the possibility of needing nursing home care. But I want to explain long-term care insurance, not in terms of what it does, but how it's set up. And I'm going to use an analogy because, again, more people have more familiarity with auto insurance than they do with long-term care insurance. So I'm going to use auto insurance kind of as a straw man here to explain how long-term care insurance is similar in some ways, but different in other ways. So let's take an automobile insurance policy. One of the main components of an automobile insurance policy, aside from the premium, of course, is the deductible. And most people in this room probably understand how a deductible works. Nevertheless, I'm going to take 15 to 20 seconds to explain it. The deductible is the share that we as the insured pay first in the event that there's an accident. So if I have a car accident, it's going to cost $3,000 to fix the car. I have a $1,000 deductible. I write the check for $1,000. The insurance company writes the check for the remaining $2,000. That's how a deductible works in an automobile insurance sense. It's not exactly the same with long-term care. It is from a cost-sharing standpoint, but how it's calculated is very different. That's where we have what's called the elimination period. The elimination period is the functional equivalent of a deductible with long-term care insurance, except it's measured in a period of days or months as opposed to a dollar figure. So basically what it means is the long-term care policy determines what length of time someone has to be in a facility before the policy pays. Okay? And as you can imagine, just like with automobile insurance, right, as a general rule, the higher the deductible, the lower the premium, right, because you're absorbing more of the risk. Similar concept with elimination period. The longer the elimination period, the longer you agree to privately pay before the before the insurance policy pays out, the lower the premium is going to be. Okay, so that's important for people in this room. who either have long-term care insurance or are considering getting long-term care insurance, those are some of the factors that we need to look at. Does the policy have inflation protection? Usually how long-term care policies are measured is they pay out a dollar figure per day. Well, you could have taken out a long-term care insurance policy 25 years ago that pays $100 a day. The $100 a day paid for everything back then. It pays for about a fourth of this thing now. So is there inflation protection built into the policy? The length of the payment, that's another important aspect, okay? We talked about the elimination period. Policies also will typically have a period of months that they will pay. A common one might be 36 months, 48 months, 24 months, whatever it is. So if somebody stays in that facility longer than that period, then the coverage runs out. And how does that become a problem? Well, it becomes a problem based on statistics more than anything else. When it comes to nursing home stay, there are two large pockets of length of time that people are in nursing home. One large period is a very short period of time. We've learned about it, but a lot of people go to a nursing home for their last days on earth. They have an illness, they have a situation that really can't be rectified. They pass away shortly after entering the nursing home. Now, of course, that group, if that period is less than the length of the elimination period, the insurance company doesn't pay it back. Okay? And the insurance companies know this, right? The second large group are the people who end up having to be in a nursing home for well beyond the length of time for nursing home, for the length of the payment under the long-term care policy. People who have Alzheimer's or dementia. These are people who, generally speaking, their body is fine, but their mind is not. They can live for a very long time, oftentimes well beyond the length of payment under the policy. So again, like with anything else, you need to weigh the risks, the costs, the pros, the cons. The final point I want to talk about with long-term care insurance is what I call the use it or lose it mentality. It used to be that traditional long-term care insurance was just that, use it or lose it. Either you do have the long-term care event and it pays out, or you don't have the long-term care event and it doesn't pay out. Well, now a lot of the policies have what are called hybrid models. If you don't use it, it converts to a life insurance policy and it pays out. So you're guaranteed to at least get something out of it. So again, these are all discussions to have, and make sure that you understand the pros and the cons of setting those up. So that's long-term care insurance. I want to talk a little bit about funeral trusts now, okay? Funeral trusts, I'm a huge fan of. As an estate planning attorney, I'm a huge fan of funeral trusts. What I'm not a huge fan of is that they're called trusts. Because when people hear that it's a trust, they think that I, as the estate planning attorney, draft them, and I don't. Client First deals with this. They're the ones who create the funeral trust. They're the ones to talk to about the funeral trust. It's just unfortunate they're called trusts. So let me explain a little bit about how this works. Funeral trust allows you to set aside a sum of money that can be used for final expenses. Again, going back to the life insurance example I mentioned before, we talked about the perils of listing or of having a life insurance policy to pay out for those final expenses. It could be recaptured by the nursing home if you need that care. They could require you to liquidate that policy. Not true of funeral insurance. There's a $15,000 exemption. That if you set aside money in a funeral trust, it's protected from nursing home estate recovery. Why is that important? Because again, every single one of us, regardless of what our preferences are going to have costs associated with our passing. And this allows you to protect those assets because again, going back to my example from before, if we require to liquidate that policy, someone's going to have to pay for those final expenses. And it's usually the kids who have to pay for that. By having a funeral trust, we set that aside. Now, another question I frequently get is, what if there's too much in the policy? In other words, let's say you take my advice, you create a funeral trust, and you fund it with $10,000. And after all of the expenses are said and done, the cost of the funeral is $7,000. What happens to the remaining $3,000? And the answer is, it depends. People hate when we lawyers use the phrase, it depends. I get it, okay? So what do I need more information on? I need more information to know, did this person or did this person not need governmental benefits to pay for nursing home care? Because the answer to that question enables me to answer the question. So let's divide it into the only two possibilities, yes and no. Let's start with no. If that person did not need governmental benefits to pay for nursing home care, then the $3,000 goes by way of whatever the estate planning document says, usually to the kids. Okay? So that's easy. What if the person, on the other hand, did need those nursing home benefits? The answer is the money then goes back to the state, which sounds bad, but it gives us a little bit of a planning opportunity. And let me explain what I mean by that. Again, going back to what I know is going to happen, I am 100% certain that I will know once somebody passes away, whether they did or did not need governmental assistance to pay for nursing home care. It's not going to change after death. If that person did need nursing home care, and we know that that amount is not going to be sufficient, we can plan. We can have a bigger event. Instead of deli sandwiches and sodas, we can have steak and lobster and open bar, right? We have that opportunity. Because here's what I can say. I try to boil my practice down to simple questions, okay? Questions that I know I'm going to get 100% or pretty close to 100% agreement on. If the only two options were have a really nice party or have the money go back to the state, I don't think anyone here is picking the state. Okay? I could be wrong. Maybe you want the state to get that money, but most people don't. So again, it's a planning opportunity. The funeral trust allows you to do that. Because again, this is an event we know with 100% certainty is going to occur. Final point I want to make on this is this. When it comes to funeral trusts, a lot of times when I advocate my clients get funeral trusts, sometimes I'll be met with the question of, well, why don't I just go through the funeral home? And that's a fair point. But here's the problem with just going through the funeral home. One, we don't know if that funeral home is going to be in existence. They could go out of business. Secondly, that funeral home that did such a good job with maybe other relatives, maybe they will undergo new management. Maybe they were excellent before, but with the new management, they're a lousy funeral home. What if we don't want to live in Wisconsin anymore? I realize it's a beautiful 60-degree day today, but it very easily could have been 15 degrees today. And encourage people to want to leave this wonderful state we have. Well, if you have it set up through a funeral home, you can't use it there. The funeral trust they set up for your client first can be used anywhere. They're 100% portable. If you want to use it at ABC Funeral Home where all of your other relatives were so happy with the service, you can do it. There is no downside to creating a funeral trust. So again, I'm a big proponent of them. You can certainly talk to the folks at Client First about more specifics. Absolutely. Funeral trusts are separate. You've already irrevocably given the money away. So it is not going to impact your ability to receive Social Security. Yeah. Basically, a funeral trust is an irrevocable assignment of the money. Yeah, it typically is, but again, it has to be used at that particular funeral. Yeah, that's their whole business incentive for setting it up there. So they may have it through another company, but overall, that's what they're doing. Okay, I mean, they don't store it in the safe in their basement in cash. I mean, they have it invested through another product there, but it has to be earmarked for that particular funeral. All right, very good questions. So I just want to talk a little bit about senior housing. I know I'm running a little over time here, so bear with me. When it comes to senior housing, a couple of key things to think about. One, what do we do with the principal home? A lot of times people want to downsize, people want to make the home accessible, get in-home care. These are all possibilities. The main point that I want to discuss with senior housing is this. If and when we get to a point where a loved one needs an assisted living facility, or memory care, or skilled nursing facilities, every single one of those facilities is going to have an admissions contract. Paperwork that governs the rights and responsibilities of the people who are being admitted. I'm going to start with the good news. It's very rare as an estate planning attorney I can use good news, so I'm going to start with that. The good news is Wisconsin right now does not have what are called filial responsibility laws. In English, kids don't have to be responsible for the nursing home debts of their parents. Most states have that, but Wisconsin does not presently. Here's the bad news. Some nursing homes or some assisted living facilities, as a condition to admit you to the facility, will require the children to be financially responsible for their parents. So it is very important to review those documents before you sign them. And again, if you want to incur that liability, great. You have to be made aware that you're incurring that liability. So again, I would strongly encourage, before you sign any paperwork to admit one to one of those facilities, that you have an attorney review it and make sure you understand the rights and responsibilities under that document. Okay? It's the ounce of prevention is worth a pound of cure type thing. I got that right the second time today. I always mix that metaphor up. I took my time and I got it right. So again, I want to thank Client First for the opportunity to speak here today, and I will be available in the back for questions at the end. I know Paul is approaching the podium here. So again, thank you for the opportunity. Have a great night.
Thank you, Rob. What a nice job. Does he do a nice job of just kind of simplifying everything? I think so. So we're going to wrap up here real quick. And you have some feedback forms, and we love your feedback. One on the content, two the delivery, and three of the other ways we can help you. So if you want to fill those out, and then when you're ready, our team is in the back. You can hand those in there. We'll take a look. And then next month, we're going to cover the markets, right? It's been a little choppy lately, right? We can all agree on that. And so the adaptive team is going to be doing that. You guys know David, you guys know Ian, you guys know Kevin. We have a new team member to announce. And so I'd like to bring up Dan, if you could. So Dan Garguber is going to join our team. Dan is from Minnesota. He is a North Dakota State Bison. This is undergrad. He ran track for them. He is a chartered market technician, which is CMT. He's married to his wife Dana, works in healthcare. I'll let him tell you his favorite NFL team. You can probably guess that. David loves it as well. And we're super excited. He's going to be around in our office like 6 weeks a year, but then connecting digitally as well. So we're super excited that he's here. There's only 1,700 CMTs in the world. We're going to have 4 of them. So we feel like kind of cornering the market as well. So we're super excited. I want to bring Dave up because it's going to be on Dave's team. So I'm going to turn the mic over to Dave real quick.
No, I just want to welcome him to the team. He's been here for almost 2 weeks, getting a crash course in how we do things. And I got to give him a lot of credit. He's been grinding. Kevin and he have been learning a lot of things together. And so I want to give a round of applause because the amount of grinding and work he's put in the last 2 weeks has been pretty impressive, and it's going to make us better. So thank you. We look forward to it. Thanks for being here.
So yeah, he's also, I just learned this, he's a big cribbage player. So yeah, right? So if you got the chops, let's see if we can do this. So welcome to the team. Oh, Dana's better?
Dana's better.
Okay. All right, so welcome to the team. We're super excited about it. All right, so that's Dan. You'll see him next month with the team. You'll also see Ian, right? Because Ian lives in Charlotte. He'll be up as well. All right. That's the team. You know, our tax team isn't here. They weren't at the new one as well, right? Because it's kind of March Madness for tax time, right? I know you guys are filling out your brackets right now. They're filling out 1040s, right? So I want to let you know April 8th is the last day we take any new information. So if you haven't done your taxes already, or you know someone who hasn't that you think would be, we could help, let them know April 8th is the last day that we're going to be accepting new information. You guys know where we're at. We've loved being in that new space. It's been great for clients. No elevators, no stairs, no breadcrumbs trying to follow where we are. So we're super excited about that. And with that, we will conclude. If you need any other questions answered, Rob is here. Our team is here. Otherwise, just give us a call at our office. We're really happy to help you with all the different financial puzzle pieces that you have. So thank you. You're welcome to stay. If you want another drink, have it. Enjoy each other's company. Thanks for coming out. And enjoy a nice spring evening in winter.